our webinar today, The Complaint Process Overview, What's New and What's Not. It's being presented today by the Interagency Sexual Ethics Task Force, which is convened by the General Conference on the Status and Role of Women. The webinar itself, technical support and registration, is being provided for us by the General Counsel on Finance and Administration. Our presenters today are Rick Retberg, General Counsel at GCFA, Darryl Stevens, the Assistant General Secretary for Advocacy and Sexual Ethics at Crossroads, and me, Joy. Our instructions are really pretty simple today, but we put them on a slide just to make it easy. This webinar is being recorded, and it will be available on GBHEM's Cyber Campus site by early October. Your phone has been muted. During the presentation, please type your questions into WebEx. During discussion time, later in the hour, you may raise your hand to ask a question over the phone. The resources and documents are available to you at this link that you see at the bottom of this slide. I'm going to turn it over now to our other presenters, Darryl Stevens and Rick Retberg.
This is Darryl Stevens. This webinar is titled Supervisory Response Process, What to Do and What Not. We will be examining paragraph 364 of the new Book of Discipline 2012. The purpose and focus of this webinar is to discuss changes to the complaint process that will be effective January 1st, 2013. All disciplinary references in this PowerPoint refer to the Redline edition of the 2012 Book of Discipline. The focus of this webinar is the supervisory response to complaints of clergy sexual misconduct. That will be our example issue today.
Okay, this is Rick Retberg. We're going to begin kind of with the substance of the changes that have been made to the Book of Discipline at the 2012 General Conference. And to begin with, we're going to need a basic change in the terminology that we've been using up until now. And we've been talking about references to administrative complaints and judicial complaints. Well, on January 1st, when the new changes go into effect, there will only be judicial complaints per se. Administrative complaints have kind of been demoted to, well, I'm not saying demoted, but they're relegated to a small c complaint. In other words, a person has a concern about a clergy person, they will bring that to the attention of someone, and that will be processed through the Board of Ordained Ministry. And that whole process was the subject of a webinar that was done by the General Board of Higher Education and Ministry on September 12th, which if you were not able to join it, will probably be available online as well. So again, now from after January 1st, when we refer to complaints, we're only talking about judicial matters, that is, chargeable offenses. And so in order to determine whether or not the matter you're dealing with is a complaint, you need to look at the list of chargeable offenses for clergy in paragraph 2702.1. And I don't believe that list of charges has changed at all. That's the same. But administrative fair process is the term that we're using now instead of complaints. Do you want to talk about that, Darryl?
The one change in the chargeable offenses paragraph is the removal of failure to perform ministry, which is now administratively handled.
All right. Okay. And of course, the paragraphs have been some of the paragraphs have been renumbered. So paragraph 364 is the number which has been tentatively ascribed to the complaint process by the publishing house, and we'll assume that that's what the 2012 Book of Discipline will also reflect. Darryl's going to talk about an example of the difference between these two processes.
an example with Pastor Smith. A letter signed by the SPRC chair arrives in the bishop's office alleging that Pastor Smith is destroying his congregation because of his behavior, ill-prepared sermons, disrespect for the trustees, lack of administrative skills, etc. Question, is this a complaint? Answer, no. This is not a judicial matter. It should be handled administratively. So ineffectiveness is not handled as a complaint anymore. It's handled under an administrative fair process. This webinar will focus on the complaint process. Another example, Reverend X. A parishioner calls the DS to report her suspicion that Reverend X is using internet pornography on his office computer. Question, is this a complaint? Answer, no, it is not a written and signed statement. A complaint must be a written and signed statement. After speaking with the DS, the parishioner agrees to put her complaint in writing. The DS receives the signed letter later that week. Question, should this allegation be handled as a complaint? Answer, yes. Pornography use on church-owned equipment is a form of sexual misconduct, according to the Book of Resolutions, which is a chargeable offense.
Okay, we're going to move on a little bit to talk about the timeline for complaint procedures. Once a written and signed complaint has been received, the supervisory response process begins. The time has been changed for resolution of complaints, so that a complaint has to be either resolved through the supervisory process, referred to a counsel for the church for trial, or dismissed within 90 days. There's a possibility of one and only one 30-day extension, and the term used in the Book of Discipline for this is abeyance. Well, the one exception is abeyance, right? And a complaint can be held in abeyance, which it can be held in abeyance indefinitely, but that's subject to review every 90 days to see if the circumstances which warranted the abeyance are still extant, and the bishop and the Board of Ordained Ministry need to be on top of this. And this is to deal with the kind of situation where there may be a pending criminal investigation by the civil authorities, local prosecutors, et cetera. And probably the best rationale for placing a complaint in abeyance is not to interfere with the outside investigation. But the word abeyance is new, and it's not. It has not currently been in the Book of Discipline. It doesn't seem to be a term that is subject to a whole lot of definition or parsing. As an attorney, I would view that word as meaning the same thing as a stay, but evidently that particular word was added from the floor of General Conference and was not discussed by the committee. So whether there will be any issues concerning the definition of that word remains to be seen. Okay, Joy, I think, is going to talk now about the timeline.
Here we have a chart that shows you a timeline describing the previous slide that Rick just gave us. You see on the left-hand column, this supervisory response timeline begins with the receipt of a formal complaint, not a phone call with an allegation, but a written and signed statement. Then the 90-day supervisory response term of days begins. The supervisory process will involve the person bringing the complaint, the person responding to the complaint, the bishop, the Board of Ministry, and others, especially perhaps the response team and the congregation. On the far right column, you see the possible outcomes that can be achieved during a supervisory response period. We may resolve the complaint. We may refer the complaint for trial, or the complaint may be dismissed. During that period of time, the respondent can be suspended with the approval of the Executive Committee of the Board of Ministry. And the only exception, as Rick said, is if the whole thing is being held in abeyance because the matter that is in the complaint is being litigated in secular court. If that is going on, then the resolution may be put into abeyance for a period of time. I think we can go on to the next one.
Okay, a new requirement is that when a bishop receives a signed and written judicial complaint, then he has the obligation to notify the chair of the Board of Ministries of the complaint. And we've included a reference here on the PowerPoint to the Book of Resolutions. There's a new resolution dealing with the supervisory response and the care of the various constituencies involved, and the use of intervention teams. A number of the annual conferences have quite excellent intervention teams that are interdisciplinary groups that will respond to these kinds of crisis situations. So we commend that to your reading.
We will revisit the example of Reverend X. In the case of Reverend X, how long should the DS wait before forwarding the complaint to the bishop? The answer is no delay. The timeline begins immediately upon receipt of the complaint. So as soon as the DS receives a signed written complaint, that should be given to the bishop. The 90 days has begun. In the case of Reverend X, since the complaint involves pornography use, the bishop would like to investigate before sharing this allegation with anyone outside the cabinet. Question: can the bishop do this according to the discipline? That is, can the bishop wait? The answer is no. The bishop, and this is new legislation, the bishop shall notify the Board of Ordained Ministry chair that a complaint has been filed. Additionally, the respondent must be notified. Reverend X continued. Question: rumors of Reverend X's alleged pornography use have created disruption in his congregation during the supervisory response. Does the bishop need to respond to this? The answer is yes. Bishop and cabinet shall provide the process for healing within the congregation, annual conference, or other contexts of ministry if there has been significant disruption by the complaint. The new resolution 2043, Response Team Ministry, provides guidance for congregational disclosure and intervention. The full text of this resolution and other resources are available on the unsexualethics.org website.
Here is another chart for us to look at so that we have a visual way to think about supervisory response outcomes. When a complaint is received, you see in the red box on the left, it may be dismissed by the bishop following cabinet consultation and documentation of the file. Or it can be referred for trial according to paragraph 2704 within 90 days of receipt from the bishop, by the bishop. Or on the right-hand side in the bright blue bubble, you can see that a just resolution process may be the outcome. In all of these situations, the bishop should notify the Board of Ministry of the supervisory response outcome. And once again, we don't have on this chart what might be the outcome in the situation of abeyance. We don't know how that's going to work out yet because we haven't lived into it yet.
I just wanted to add one thing. I mean, the question that's likely to come up in abeyance is one that we get here at GCFA all the time is, well, does the pastor have to be paid during a period of abeyance? And the answer to that is a resounding, we don't know. That issue is in front of the Judicial Council in October in a somewhat different context, but we'll have to wait for that decision and see if that provides any guidance for what might occur during the abeyance of a process.
The first question is from Ethan Mills. Is a pastor on suspension during abeyance beyond the 90 days?
Yes, that's possible. We believe that's possible, but as Rick said, we haven't faced that actual situation yet, and I believe that it's going to have to be faced on a conference-by-conference basis. And Rick and I and Darryl, I believe, are in agreement that that's the probability. Rick, can you add more to that?
Well, you know, it's always difficult to advise people on this sort of thing because the only party that can definitively answer the question is the Judicial Council. Darryl? I
will read some of the text of this new legislation, and for those who would like to read the red line edition of this, there's a link on umsexualethics.org to resources for this webinar. And one of the links is to the new Board of Ordained Ministry paragraphs. This would be within that document on page 29. This comes from paragraph 364.1G. The time in which a complaint is held in abeyance shall not count toward the statute of limitations. A clergy person shall continue to hold one's current status while a complaint is held in abeyance. Now, what is unclear in this legislation is whether the current status would include suspension if the clergy person were currently under suspension.
We're going to move on. The next question is from Rich Marsh. Does the bishop need to receive the written signed complaint before timeline commences for supervisory response? Can 364 be read in this way?
Rick, I think that's your question.
Yeah, I think the answer to that is that yes, the complaint does have to get into the hands of the bishop, or at least at the, is delivery at the bishop's office sufficient? Again, this is where you get into the murky areas of this sort of thing. But I think in general, the bishop needs to receive the written signed complaint for the timeline to begin.
And the next question we received from Steve Goodyear: what authority does the Book of Resolutions have?
Well, the Book of Resolutions is not church law in the same way that the Book of Discipline is. But it is, I would say, somewhat instructive of the intent of General Conference. It is a book that's adopted by General Conference, and I would say that the contents of the Book of Resolutions would have some persuasive value for the person adjudicating the dispute.
The next question we have is from Sue Ann Love. Can you give a nutshell explanation of the Book of Resolutions?
Yes, it's a large book. It looks very much like the Book of Discipline, only it's thicker, and it contains quite a number of writings on many different topics of United Methodist doctrine and beliefs and the social principles. Again, it's not church law, so I know, Sue Ann, you're a chancellor, and it's not a book that the chancellors would probably get into very often, but there are a lot of things in there, and frankly, some of them are not widely known in the church. So I do think, though, in terms of talking about sexual ethics, that there's a lot of good information and writing that's kind of informative of what the feeling of the General Conference is. I mean, the resolutions are all adopted by the General Conference, but they do not have the force of church law. Okay.
The next question is Stenmark. If the bishop is out of town, does timeline begin on the day the bishop receives the complaint or the day it was written?
Well, that's a good question, and that was kind of what we were trying to get at in the earlier question. Probably the best answer to that is that the timeline is probably going to begin to run when the bishop knows about the complaint. So if the complaint arrives in the office and the bishop talks to his or her assistant and says, we received a judicial complaint there, then the bishop is aware and needs to take action. I mean, again, these are niceties that the civil law provides with in great detail, so we can only talk by analogy to the civil law, but the Book of Discipline does not definitively answer all of those questions. But certainly, I think when you talk about the date that the complaint is written, a complainant certainly could write a complaint and hold on to it for 2 or 3 weeks before sending it. So that obviously does not begin the running of the 90 days. Also, if it reaches the bishop's office and the bishop is out of town, then presumably the bishops have people in their office whose job it is to open their mail and to deal with important things and to let the bishop know. So certainly bishop staffs need to be and probably are aware of the importance of receiving a judicial complaint, but they need to be aware to notify the bishop immediately. And I think just the best answer that I can give at this point in time is that once the bishop knows about the complaint, then the 90 days starts to tick.
The question is from Renee Fernandez. What obligation does a DS have to assist someone in preparing a formal complaint when the person has brought a concern to his or her attention?
I don't know that the discipline does provide any real guidance on that. I don't think we want to use the rule that a complaint has to be a written and signed complaint to be a vehicle to stick our heads in the sand when orally something is brought to our attention, particularly when it concerns sexual misconduct. It certainly is a problem if someone makes an oral complaint but says, I won't put it in writing, because ultimately one is going to need to be in a trial situation and need witnesses to prove that complaint. But if a district superintendent, for example, were to receive a phone call from somebody saying the pastor is abusing children in the congregation, but I won't sign a written complaint, I think the DES at that point needs to start doing some investigation and look around and determine if there is any basis for such a complaint, even to the extent of signing the complaint himself or herself. Again, the counsel for the church will have to assess the matter and decide whether there's enough evidence that can be brought into the trial court to prove the complaint. But obviously, given the nature of this particular type of situation where you're talking about sexual abuse and particularly child sexual abuse, there are mandatory reporting laws as well that come into play, and if this sort of thing comes to the DS's attention, the DS may have an obligation to call the authorities. But yes, if the DS feels that there is a credible charge of sexual abuse, then I would think the DS could certainly assist the complainant in preparing the complaint. It can come back at you a little bit too. I'm aware of at least one instance where a respondent was using a defense that the complaint had actually been drafted by the bishop. Well, the bishop was acting in response to a complaint made to him by the complainant. So, but yes, DSs can and often do sign complaints. They can help people with complaints. Darryl?
If you are a district superintendent or advising a district superintendent on this matter, it may be helpful to refer the complainant to the umsexualethics.org website. There's a tab for victim survivor, which explains the church policies and laws, instructions for filing a complaint and what that means. Often a layperson bringing a complaint forward has no concept of our Book of Discipline or any of our annual conference policies or church law, so they have to be guided in how to negotiate the system. Simply the simple knowledge of knowing that a phone call is not a complaint in our policy is very important. That they have to have a signed written statement is very helpful. So the website can help them through that process. And it's also important to remember, especially in the case of sexual abuse, say a clergy person sexually abusing a parishioner, that this is not a dispute between two equal parties. So the person bringing the complaint, that is the alleged victim, is a witness to a chargeable offense. Now, it may be times appropriate for the district superintendent to write the complaint herself and allow the alleged victim to be simply in the role of witness rather than complainant. The complainant does not have to be the victim. Complainant can be a third party.
We have a follow-up question from Beverly Sedmar concerning when the timeline begins if a bishop is out of town. Beverly has asked, in that case, is it better for the administrative assistant to not open the mail complaint? Can the administrative assistant respond to the complainant that the bishop is out of town and a complaint will be given to the bishop on return? Would the timeline start when the bishop then returns and receives the complaint?
In my opinion, it does not give you an excuse not to open the mail. I think sometimes our tendency when these things happen is to kind of circle the wagons and immediately go into a defensive posture. The subject of that complaint may involve some real victims out there, and so I don't think time should be delayed by the tactic of just not opening the mail. I think that it's very rare nowadays that the bishop could not be gotten a hold of and told about the existence of a complaint. And I think that if someone did this, they just simply didn't open the mail or said, well, the bishop's out of town, we'll give it to him or her when they get back. I think that the bishop runs the peril of running past the 90 days to resolve the matter, and that could cause additional problems.
Another question we have from Lisa Garvin. How is complaint process communicated to the congregation?
The suggested process for appropriate disclosure to the congregation is that the bishop or the designated person to handle the complaint, usually the district superintendent, be the official channel of information for that congregation.
So?
To determine what should be disclosed, it's a need-to-know basis. People in the congregation may have a need to know that there is a credible allegation of child sexual abuse against their pastor. That's something that congregation needs to know during that process. The disclosure to the congregation does not need to go into detail, that is to name alleged victims or dates or incidents. That is, the congregation simply needs to know that there is a complaint of this nature, and that then to inform the congregation of the church's policy and the process, that this allegation is not an indication of guilt or innocence, but that an investigation is being conducted by the church, and then to be assured that that congregation will be informed in a timely manner as that process unfolds, so that they can reliably look to the district superintendent or bishop for official information, and the congregation does not have to rely on unofficial rumors that may be circulating.
Next question we have is from Buzzy Anding. In summary, when shall a minister respondent be entitled to continue receiving salary, and when is salary not payable following the filing of a complaint?
Well, I believe that under the current discipline, the salary continues until the conclusion of the trial, and that is the issue that's before the Judicial Council in October. So, Buzzy, I'd like to give you a direct answer to that, but I think that the best answer for now is to wait for that decision and see what it says, and what guidance it will provide, if any, for what's going to happen during a process if it's held in abeyance.
The next question is from Steve Goodyear. What will the consequences of going past the 90 days be?
Well, the complaint is going to expire, and would have to begin again if it's going to have. I don't believe there's no jeopardy attaching if the complaint is not resolved within the 90 days, because that jeopardy does not attach until a bill of charges has actually been brought. So that's the jeopardy of waiting beyond the 90 days. Okay.
Well, and it would also mean that the bishop is not following our own church policies, which seems to create unnecessary liability.
Right. I mean, the first thing that the bishop's assistant should do when they open the envelope and find the complaint in there is mark out on the calendar 90 days from that date. I mean, lawyers are used to it. I know there's a lot of chancellors on the line here, so you won't have any problem with this. But those who are not lawyers, those dates that date is very, very important. So be sure that mark that down on the calendar and diary it for a week and 2 weeks and a month ahead of time, so that that the bishop can be kept aware of the approach of that date. So you don't have to really get a Judicial Council answer to the question of what happens when you went past the 90 days.
We have received a question from Meg Lafayette. Have you addressed how the Conference Relations Committee interacts with the status process when a judicial complaint is resolved?
Yes. Okay. I will get a lot of calls from boards of ordained ministry people when it's usually from the Conference Relations Committee about if a judicial complaint is resolved and part of the issue is removal of credentials. The board still has to be involved in making that recommendation for the status change. So when the judicial complaint and the administrative complaint processes intersect like that, what does the Conference Relations Committee need to know? How much freedom is there in changing the recommendation, and just some of the mechanics of moving through that?
Well, under the Book of Discipline, the ruling of the trial court is not a recommendation to anybody. It's the penalty, and it becomes effective immediately.
Okay, so the board is no longer involved then once the judicial complaint starts.
There may be some mechanical things that need to be done, but the ruling of the trial court is a judgment, and of course it's subject to appeal to the Judicial Council. But the ruling of the trial court is not a recommendation. It is important, I think, for the chancellors on the line to know that they do have a new and formal role in the new procedure, and that is that when a case is referred to counsel for the church for trial, the counsel for the church needs to act in collaboration with the annual conference chancellor. Does the bishop have authority to return a written complaint to the superintendent to deal with if, in his or her opinion, it is not truly a violation of a chargeable offense? Yes. Terry McElhaney has asked a question. I understand the Committee on Investigation is going away for clergy complaints as of 1/1/13. Are you going to comment on this? Well, again, that was beyond the scope of this webinar.
I'd like to address that question. Lynn Caterson.
Sure, Lynn, go ahead.
When we added the chancellor role in the process, the purpose primarily was to evaluate the evidence and help with the investigation. The belief was that the Committee on Investigation really didn't utilize their investigatory powers the way perhaps the former discipline was written. Bishops, I think, have a good handle on whether a complaint rises to the judicial level or not. However, I have experienced bishops not being able to determine sufficiency of the evidence, which, as we all chancellor's attorneys know, that's often the criteria as to whether we go to trial or not. And the second part of that is the need to investigate. A lot of the questions this afternoon have revolved around, well, how long does it take and what do we know and all those kind of things. And it was determined that if you have a good investigation, and again, and I'm biased as a chancellor, I believe chancellors are the best ones to direct an actual investigation, you will end up either with a clear decision that there's not sufficient to go to trial, or you'll end up with sufficient evidence that may well result in a resolution before going to trial because the respondent sees the evidence there. And that was the purpose of this new procedure in the discipline.
Okay, for those of you who may not know Lynn Caterson, she's the chancellor of the Greater New Jersey Annual Conference and is a former member of the Judicial Council. So thank you for those comments, Lynn. The next question is, would a fax or email be acceptable as a method of submitting a written complaint? Sure, but there needs to be a signature on it, and lawyers very often will also mail the original copy, even if they send a fax or an email. But I would say that notice by email or fax would be just as good as notice by hand delivery or fax. So business now is generally conducted by email, and that's certainly has become a generally accepted way of transmitting business documents. Next question is, if the DS receives information about an allegation of sexual misconduct involving the pastor and an adult, not a child, from a third party, does the DS have an obligation to act if the individual who is the alleged victim does not choose to discuss the matter with the DS? Well, that's problematic, and that I think relates to what Lynn Caterson mentioned just a moment ago, and that is that somewhere along the line in the process, if the complaint process is going to work, someone has to make an assessment of whether there's sufficient evidence to prove the complaint. And so, I would think that at a minimum, if a complaint was received by the DS of this nature, it would certainly behoove the DS to have a conversation with the pastor. At a very minimum, and also to be aware of the potential that if there is one person making this allegation, there may be other people out there who are not talking. I mean, the goal here is also to protect victims. It isn't just to defend clergy. So, and it does involve a matter of discretion and sensitivity, and we all get hung up in the legal process here. We do have to remember first and foremost who we are, and we are the church, and so we can't abandon pastoral concerns simply because it may involve a legal process ultimately, and something that we'd rather avoid.
This is a supervisory responsibility of the district superintendent. If the district superintendent has credible knowledge of an incident of abuse, then regardless of whether the individual alleged victim is willing to sign a written complaint or be a part of that process, there's a supervisory responsibility to look into it. And as Rick said, there may be other victims who have not spoken yet. So prudent investigation.
I would also add that if such a report were received by the district superintendent, that it would also be important to place an accurate summation of that report and what was done in the pastor's supervisory file, so that if it comes up again, it doesn't, if it comes up again, say 5 years later, it doesn't look like it's the first time this kind of complaint has ever been received. So an accurate report would say we received a complaint. The person, the alleged victim of this situation chose not to file a complaint, so no complaint was filed, as opposed to any judgment of guilt or innocence, because obviously the pastor enjoys a presumption of innocence, and there's not a finding of guilt unless and until a trial court says there is guilt.
Does the general board provide talking points for DSs for these kinds of investigative conversations?
I will say for GCFA on the legal department website, we have a checklist for conduct of a investigation into a complaint of sexual misconduct. So in terms of actually conducting investigations, I would think that it's always helpful, even early on in the process, if there is a complaint of a serious nature, for the district superintendent and/or the bishop to talk to the annual conference chancellor, bring them in early so that investigative opportunities are not missed, it is taking a statement from someone, for example, is an art. It's not a science. Lawyers are trained to do this sort of thing. Other people, of course, are trained to do it as well, but not everybody is. So if you need help in the early part of the process, then you should ask for it. And certainly talking to the chancellor is a very, very good way to begin.
We've got another question. What happens if a complaint is received, but Board of Ministry Executive Committee does not concur with the bishop's request for suspension?
Well, the Board of Ordained Ministry Executive Committee has to agree to the suspension, or there is no suspension. I mean, that's what the Book of Discipline provides. Now we have a question that's just come out of the last one. Does that stop the complaint process? The answer is no. It does not. It just would keep the pastor in the pulpit while the complaint process went on.
Well, we thank you all for joining this webinar today. Thank our presenters, Rick Redberg and Joe Mel. This is Darryl Stevens.